Any mention? Item number 1.
Looks, there's an application seeking confirmation of delay. There's a delay of 12 days in filing the appeal, Milits.
What about private respondents?
Notice will have to taken steps, Milits, but service isn't complete as yet.
Then you have to wait for them.
Notice will have to call.
How many private respondents are there?
Well, it's all together, there'll be 9, 10, 11, 12, 9 to 14 Milits. That will be about 5.
Anyway, Office indicates 27/8/2024 indicates that service reports are complete with regard to respondent 9 to 14. When do you want it? Will obtain status.
Well, it will obtain status.
Mr. K. Paul, Senior Counsel, please email out obtain status and to file service affidavit if necessary. Based on because conversation
After a week, Milits.
after 1 week, please.
Apply launch.
Item number 2.
For this bench.
Lordship,
Yes.
before I move my condonation application, I'll just take 2 minutes time of my Lordship to point out the circumstances under which the order was passed. Your Lordship will just come to page 29.
I think that is
29.
29.
Yes.
This is the improved order. And I take to page 32.
Well,
Mr. S.P. Mahanta, Learned Indian Counsel, assisted by Mr. D. Dakhar, Learned Counsel appealing for the respondent number 4, submits that the issue and contention raised in these writ petitions have already been decided by a coordinate bench of this Honorable Court in WPC number so-and-so, so-and-so, by judgment and order dated 5/6/2024, whereby the writ petitions are dismissed on merit. He submits that the present writ petition should also be decided in the light of the said judgment and order. Mr. N.D. Shulai, learned AAG, assisted by Mr. So-and-so, learned GA, appearing for the state respondent number 2 and 3, supports the submission made on behalf of the respondent number 4. Mr. W. Jarwar, learned counsel, appearing for the petitioner, does not dispute the submission made on behalf of the respondent and submit that necessary order may be passed by this court. In view of above, these 2 sets of writ petition are also dismissed in terms of the judgment and order dated so-and-so. So, Your Lordship, my writ petition was dismissed in terms of the coordinate.
case covered.
And there is a writ appeal filed against this order. And this Honorable Court has rendered the order at page 152, Lordship, page 150. Your Lordship will just come to page 150. Admit, Lordship got it?
Yes.
Admit notice. The proceeding before the authorities can continue on day-to-day basis without adjourning the matter beyond 7 working days at any point of time, and the final order shall be kept in abeyance. It is open to both the parties to move this court depending upon the urgency. It is needless to mention that the condition mentioned supra is only on a condition that the appellate shall deposit 30% of the demand within a period of 1 month. In case of non-deposit of the amount as ordered, it is open to the respondent to proceed with the coercive actions. Your Lordship, along with this order, I approached to the DO at page 152 and at relevant 153 at period number 2. That our writ petition WC number so-and-so was dismissed in terms of the judgment and order dated so-and-so, and therefore allowed us to deposit 30% of the demand within a period of 1 month, as per condition as mentioned in order dated so-and-so, appeal number so-and-so, by the Honorable Division Bench of the Honorable High Court of Meghalaya, and all other order passed by your honorable court office may be kept in abeyance till the final disposal of the case. This prayer, your lordship, was rejected by the DO at page 154, last page, paragraph 6.
Yes.
The request made by Shri Sharad Gyomka at page so-and-so are rejected. At sufficient time, opportunity already given, and the court order dated 30th/7/2024 passed by the Honorable Division Bench of the High Court of Meghalaya in appeal WA number so-and-so is not applicable in this case, and you are not a party in the WA number so-and-so. So on this ground, your lordship, my prayer was rejected. My writ petition, lordship, was dismissed not on the merit, but in terms of the judgment passed by a coordinate bench,
Yes.
which was not disputed by me at the relevant time, your lordship. And that order, which was the base of dismissal of my writ application, is under challenge before your lordship. This court, your lordship, has passed one order that deposit 30% of the demand amount, and a final order is not to be passed. That same thing applies to me also, your lordship. I made a prayer. So, your lordship, pending disposal of my condonation application, I have also filed an application under section 151. Your lordship, I am not seeking any fresh order from this honorable court. The order which has already been passed by this court should be made applicable to me. So far, it relates to the writ appellant, because in this case, your lordship, there are 3 lessees in respect of the one lease land.
Yes.
Only one has approached this court, other 2 have not joined, for the reason best known to them. So that order, your lordship, which was rendered by the division bench of this court, should be also made applicable. That is, your lordship.
Why were these cases not heard together with the?
Yes, earlier writ appeal.
No. The 2 cases which is referred to.
Yes,
in
lordship.
the order
Which was disposed earlier. Which was
The
disposed.
sound and substance covered case.
No, yes, that is all. It was dismissed on the ground that it is a covered case.
Just, 1 second. The only thing that the court have to examine is whether those cases, sound and substance cover your case also.
Yes, lordship.
Then there's no reason why the order of the division bench not apply to you also.
Yes, lordship.
Yes.
It is but natural, lordship.
My lord, since they have also come on appeal, a similar order can be passed that they should deposit 30%, my lord,
Yes.
Yes, lordship.
and the matter will be heard.
And so for delay,
The slight technical hitch is this, that the single judge's order is passed by one of us.
My lord, page 123.
And so whether this bench can pass any orders, since that order itself is on appeal.
lordship, actually, I am not seeking any fresh offer.
Stand General, you're seeking relief for your client.
Yes.
But at least do not put the court in difficulty.
No, definitely not, sir. Definitely not, your lordship. Had your lordship been passing a separate order, then it would not have been possible.
You see, you just you try to understand. Now, what has happened is that the order passed by myself sitting in single bench is under challenge before the in writ appeal. And writ appeal, certain interim orders have been passed, for which you seek the same, treatment under the cover of that interim order. So that order on the challenge, whether this court, as like myself sitting here, can pass such orders.
Your lordship,
I think it's appeal over my own order, it amounts to that.
lordship, my respectful submission, your lordship, would be there is no impediment as such. And otherwise, your lordship, I will be thrown out. They have issued me a notice that if I don't pay, I will be evicted. And that order is rendered. And I'll be on the road, your lordship.
By the order of 10th of June, my lord,
The
it's
entire
more than
basis
2.5
for
months.
the interim, the entire basis is the orders passed by myself sitting singly. Whatever has happened. I
But
don't
in
think-
this writ appeal, your lordship, that order is not under challenge. Your lordship's order is not under challenge.
mutatis mutandis. Sorry, on technicalities, this matter cannot be taken up by this bench. This is a matter before another bench without me practicing.
Your lordship will give me some.
Mr. General, my sympathy and everything is with you, but sorry,
Your lordship, some sort of order that DO will consider. At least that much, your lordship, something should be
Okay, take down. Take down.
the estate officer.
So wait, the district appeal has been preferred against an order dated 10/6/2024, passed by the passed by single bench, wherein while disposing the same, it has been observed that the instant the writ petition had already been decided by a qualified bench of this court in WPC number 343 of 2022 and WPC number 344/2022 by judgment and order dated 5/6/2024. Stop. It appears that the said judgment rendered in the aforementioned writ petitions have been subject to challenge in
Writ appeal number,
writ appeal number
page number, your lordship, 150.
in writ appeal number 44 of 2024, wherein an interim order dated 37/2024 has been passed, giving some limited protection to the writ appellants. Stop. Mr. Vicky Jindal, Senior Counsel, assisted by so submits that as the matters are situated are on the similar set of circumstances, and as the writ petitions were disposed of in view of the early orders under challenge, he be given similar treatment. Stop. This court understands and appreciates the prayers made by the Senior Counsel, but however, due to technicality with regard to the orders passed by single bench, no interim orders can be forthcoming. This is matter before.
Your lordship,
Please listen. This is matter before any other bench at all. So and so. The defense authorities are liberty to take. What should we say?
consider, your
Liberty to
lordship, consider.
consider the case of the writ appellant in view of the non-availability of the bench currently.
I oblige your lordship. On condonation, your lordship may issue notice. On condonation.
Partial orders of condemnation.
Any mention? Item number 1.
Please, Your Honor, Your Lordship, Lordship, on the last occasion, the division bench has passed an order that the state will take instruction that it contemplating that the exemption of the provisions of Rule 8 of the, so that they are asking for time, so the status require.
You know what, last order, Mr. Khan, where's this report? You find it?
Lordship, if I may just give a bit of a background. Lordship, what happened is Rule 8 of the, if I may...
Prevention of cruelty to animals.
Lordship, the Rule 8, Lordship, as it stood on 2017, this is a rules made under the Central Act, Prevention of Cruelty. So the rule specifically, the case of the PIL petitioner is that state should enforce the direction given in the rules. The direction is this: within state and international borders, no market should be organized within 25 kilometers and 50 kilometers. You know, when they filed in PIL and when this law was enforced way back in 2017, in 2018, Lordship, government brought about a draft rule.
Which government?
Central government, Lordships. Draft rule amending the rule, and the limitation of 25 kilometers and 50 kilometers has been done away with. Now, this fact, Your Lordship, this fact is stated in the draft rule and which is yet to see the light of the day.
So draft rules, but then draft rules won't be implemented. It's still. So what is the situation now?
No, Your Lordship, we had the state is not sure exactly what exactly is the situation between 2017 and 18. So we had taken preliminary steps. The whole set of committee has to be.
Let's see. 34.
Yes.
One second.
Lordship.
What about your order? The order is 13/3/2024. You give an undertaking that you're making a total contra submission now.
No, Lordship, we have.
The factum of the new rules nowhere to be found.
Lordship, let me just clarify. After the PIL was filed, we have filed a number of.
No. 13/3/2024 orders with you. Just have a look, please, kindly. 13 March 2024.
Lordship, yes.
You kindly read it.
When the matter was taken up for hearing, Learned Counsel for Petitioner submits that the response to report 1411/2023 has been filed on 12/3/2024. Learned AG would submit that wherever the distance is not maintained with regard to livestock market as contemplated under so and so, the government is taking steps to provide alternative place and ensure that distance of 25 kilometers is maintained. We would further submit that he would go to the affidavit dated filed with the petitioner and find out the exact position about the existence of market and ensure that Rule 8 is complied with as requested. AG post the matter on 4/4/2021. Lordship, allow me to clarify.
And 13/3, it follows,
Lordship,
it
yes.
comes up on 17/5.
17.5. Now,
Then 17/5, you say that you want 10/5 status report. Status report on what?
Lordship, state what has
On
happened.
location of markets.
Lordship, yes. Lordship, what has happened when the PIL was filed, we had filed different reports to say what are the steps we have been taken for compliance of Section 8. Committee was constituted.
So now you come to a different story that Rule 8, whatever is sought to be changed. Correct?
That was a subsequent development, Lordship. So far the
That's reflected anywhere in the
no, it's not been reflected, Lordship. I just come to the Lordship why this draft rule.
Come to the point, yes.
This
Where's the draft rule? Let us have a look.
draft rule, Lordship. This draft rule was brought to the notice of this court. I mean, my friend is sitting there. She filed another PIL. No, that is where the situation changed a bit.
What other PIL?
Lordship, if she can apprise, she brought into notice that government should not shift the market.
You are representing someone else. You're impleted yourself
I'm the
here.
intervener, right?
And then her PIL
Item number
was,
2.
she had to withdraw the PIL saying you can implicate yourself as a party. So there
Lordship, actually, she filed a miscase in this in
Who
their
are
PIL.
you, who are you representing?
I am representing the farmers who are rearing the livestock, not for consumption, but rearing livestock. So why this makeshift market is important for them?
Then what do you propose to do, Mr. Khan?
Lordship, so far our primary stand is concerned 13/3/2024. Lordship, we have complied with, they have filed an objection to our compliance and we said like, we'll see what is to be done. In the meantime, Lordship, when there's another PIL came and this draft rule was brought into notice, then I had to
That
make,
means you're not aware of the draft rule, but the draft
No.
rule will not be effective as yet.
Lordship, we were not aware of it. Then Lordship, we had to make a summation that maybe should we,
If I may, my lord. If I may.
Because we have to proceed in terms of the order period 13.3.
Lordship, Lordship,
Whatever it is, whether you like it or not,
absolutely.
there might be a presence of other draft rules, but then if we have given undertaking to the court,
Lordship, yes.
you give this report.
Lordship, we have given a-
15 kilometers. We're not saying that in order to close them down right away.
Absolutely,
But
absolutely.
just the whole thing has to be examined as proper perspective. that's all.
Absolutely, Lordship.
We file a status report.
Then Lordship, kindly give us some time to comply with the application filed by the petitioner.
Yes, today on the matters taken up, Mr. K. Khan, an AAG, has submitted that that Rule 8 of the prevention of cruelty to animals, regulation of livestock market Rule 2017. In the process of amendment, wherein the requirement of Rule 8 of the rules.
But these are central rules, my lord. There is no such proposal as far as my instruction, my lord, of amendment of. the rules.
There's also, my lord.
No. That under this recording submissions. No. In the process of adding amendments. The requirement as stipulated in the rules of 17 no longer exists. Stop. He, however, does not have copy of the draft rules with him. Stop. This court notes that next paragraph. This court notes that as per order dated 13/3/2024. Stop. The state respondents were to provide the details of the exact location of markets, livestock markets, and by order dated 17/5/2024 have sought further time to file the status report. Stop. Like as the status report on board as create further, how much time?
Lordship, 2 weeks.
2 weeks time allowed to state respondents to file the same. As
My
simple
lord-
as that is nothing.
My lord, may I be heard, please? For
Yes.
my,
What do you have to say?
yes, my lord, I'm the intervener here. So, my lord, if I may take you to page number 25, please, of my application.
Which way is the
intervention
application?
Intervention application.
Let me see miss case number 2.
2. Yes, my lord. Miss case 2. Page
Page?
number 25. My
Yes.
lord, I am against these makeshift markets without following these rules. If I
So
may.
we'll look at that. Ms. Bag. We'll look at that when the deadline file the status report, and we'll look at that.
But it's important.
Take down also MSOA bank who's appearing. You implemented respondent number. It's really long.
My
Has
lord,
been
I'll be
implemented.
respondent number. I'll let you know. 2 minutes. I'll be respondent number 8, my lord.
Have you been implemented or not?
Not yet.
Then you file an application
No, this is my application, my lord. This is my application.
for implement.
It is a very elaborate application. If you allow me, my lord, I may just take
No,
you
this
to.
is a PIL.
No, my lord. I have filed a miscase. It's a miscase too.
Miss case number 2, but then look at the court title.
It's an application for intervention, my lord.
They should see one thing. You file a proper small application, in this case for impleadment. Then we'll take up, the meat of the matter. We would say livestock market. Yes.
But my lord, I had to bring these.
It's all right. You bring on the record, but you file a miscase. Be impleaded first.
Item number 2.
Yeah.
Lordship,
Yes.
the state respondents have filed their affidavit in opposition. I pray that I may be granted 3 weeks' time to file rejoinder, my lord.
You are whom, the petitioner?
Petitioner, my lord.
But, we have filed the affidavit. In fact, my lord, the petition, my lord, which has been filed, and the main grievance of the petitioner is, my lord, that there is no weighbridge, functioning weighbridge at Dalu. But that substance is whatever, my lord, that is not correct. My lord, the
I
affidavit.
ready with the matter.
Lordship, I may be permitted to file rejoinder because the state.
Rejoinder is not by right. If the materials put in the
Rejoinder is
affidavit
not
that,
a matter of
that
right, my lord.
rejoinder is necessary, you'll examine rejoinder necessary or
Lordship,
not.
the petitioner is going for a physical verification of the spot once again, because when in the previous PIL proceeding relating to the same Weybridge matter, before this honorable.
Even the, my lord, rule has not been complied with, my lord. By
Let
filing.
her file then, yes. 1 week's time is prayed. Allow for rejoinder.
Lordship, 3 weeks
Is the
time, my
offer.
lord, because we have to go for a
1 week's
physical
time, yes.
verification of the
If there's no such substance, when did you file the affidavit?
21-6, my lord.
21/6. You're sitting in August. Yes.
Obliged.
Item number 3.
Lords, I am instructed, my lords, that the appellant does not wish to pursue this appeal any further because the matter has been settled in the school, my lords.
Okay,
The petitioner has somehow been adjusted as against a post in the school.
okay, policy council so submits instructions that the appellant does not wish to pursue the appeal anymore. Only the matter stands closed for withdrawal.
Right.
Item number 4.
This is the item relating to the income tax matter. I have filed a petition challenging the notice as well as the order passed by the respondent number 5, my lord.
You are Mr. Bansal.
Yes, my lord.
Mr. Bansal, you did not take any steps as per the office note.
I have already filed, on the very first day, I have already served Union of India. I could not hear the court, that's why this order was passed, my lord.
Mr. Dr. Moskal, you have parents matter?
Only for 1 bill.
Yes. You kindly serve the other respondents.
I have served all the respondents, my lord.
Where the factor of service? Where 226? Oh, you're there.
Lordship, I have served the copy to the other respondent also. Last date they have appeared.
226.
Yes.
Who's planning counsel for income tax?
Mr. Chetia, it appears, my lord, he appeared on the last date on 14th May.
But he's not here today.
He's not here today. I'll inform him.
Yes, Mr. Bansal, what to do?
My lord, if required, a short time may be given to them so that it may be taken, my lord.
Yes, Mr. Dr. El Mozika attended appearance on behalf of the respondent number 1 today, and as such notice is complete, as much as certain Mr. S. Chetia has accepted notice on behalf of respondent 226. Is that counsel is not present in court today? This is a matter after 2 weeks. Yes, for the orders.
Item number 5.
But on the last one, I prayed for some time to file an affidavit, my lord.
Yes, what's the
I'm praying
matter
for some
about?
more time, my lord, Inspector.
What's the matter about? Customs?
Yes, Your Lordship.
Yes,
It's relating to betel nut.
or beaten up? Dr. El Mozika, I assisted by so and so. For how much time?
3 weeks time.
For the 3 weeks time of affidavit. Just thereafter.
Dip.
Any mention? Any mention?
Yes.
Lordship, I'd like to mention item number 19. On behalf of the council,
One
it's
second.
correspondent number 4, Mr. K.P. Bhattacharjee.
Number
19.
who's the petitioner?
Lordship, Mr. Samraso.
Why?
19.
Why adjournment for what?
Lordship, the council has a medical emergency.
Who's the counsel?
Mr. K.P. Bhattacharjee.
After what? When?
19.
Any objection? MS Vanian.
No objection, Lordship.
2 weeks or 1 week? 1 week.
1 week.
Yes.
Nice, my lord.
Lordship, I beg to mention item 15.
Number?
15.
Yes, who's there? Other side. 15. 15.
Yes, sir, Lordship. Oh, yes. Union of India. I'm praying for 2 weeks' time, Lordship. No objection, Lordship.
22 matter. 2 weeks.
Similar prayer for item 20, Your Lordship.
Where's the Chari? So he's not here today.
I was having some personal difficulty, Your Lordship, for today.
Item number?
20. I've already informed the respondent.
Yes. 1 week, yes.
My lord, I beg to mention item number 18, my lord. Praying for 2 weeks' time. And for the respondent, private respondent.
Where's your names? Where's the petitioner?
I'll for the state respondents.
Petitioner?
Mr. S. Sen is for the
Mr. S.
petitioner, madam.
S.
S. Salam.
Shalom.
S. Mr. Sen. You taken consent?
No, my lord. I'll inform
No,
her.
they let him come. Otherwise, you mentioned it's called out and here.
My lord. You can mention it.
My lord, one more matter, my lord, item number 22, my lord.
$22 years.
After 2 weeks, my lord. No
No
objection.
objection. Any urgency?
No urgency, my lord.
And 3 weeks, yes.
Much obliged, Lordship.
My lord, I would like to mention, my lord, 16. Item 16, my lord. We have informed the other side. My lord, they're here. My lord, here we are still waiting for the FSL report, my lord. And we couldn't get the
But that
status
matter's
of...
been hanging. This is that.
My lord, yes,
Nepal matter.
we tried to contact the department concerned. We are not able to reach them. So, my lord, we will try
Who's
to...
the department concerned?
My lord, the police department, my lord, who has sent the mobile phone for
Which police
FSL.
department?
Which district exactly, my lord? I think Ribhoy, my lord. It's called Ribhoy.
So they called SP here. Why?
My lord, give us,
What
my
take
lord,
so
kindly
long?
give us one more time opportunity, my lord. We will try to come up with the status of
Take
the
down,
FSL.
to MSR Colney, learned GA. Please that some more time be granted in order to obtain the forensic report. So further submits that in spite of repeated attempts, the police at Ribhoy district are not cooperating. This court notes the submission. In the event that no instructions are forthcoming for the next date, the IO in charge shall appear in person for this court.
My lord.
Yes, this is the matter on
2 weeks, my lord.
after 2 weeks, a copy of the order be given to the learned government advocate. You give it to them, if we see, yes. Yes.
Morning, Lordship. Lordship, I would like to beg item number 4. Beg to mention item number 4.
Item number?
4.
Don't mention orders.
No, sir. It's just that the respondent hearing has received the notice. However, she's not
Please
appointed.
don't mention orders. When it matters
I'll
comes
just
out. You know that. You're a local council every time. Yes.
Apologies.
Yes.
Supplementary list, item number 1.
May I please, Your Lordship? Your Lordship, in this matter, I humbly pray to withdraw Your Lordship with liberty to file afresh.
What happened?
Because one matter, or like, the matter is still pending also in District Council, Your Lordship. So,
Your senior is not here today.
he's here, Your Lordship, but he's in some other court, Your Lordship.
Yes. And if Angie submits instructions, that she this instruction prays that matter be allowed to be withdrawn. Would it be fresh if so otherwise? When the matter stands dismissed and will be withdrawn.
Item number 2.
Yes, Mr. Taba.
Your Lordship, I filed the instant revision petition under Order 6
Yes.
of the High Court of Meghalaya, jurisdiction of District Council Courts Order 2014.
Yes. What's the matter about, Mr. Taba?
Lordship, the matters challenging the impugned judgment dated 13th-9/2019 passed by the Court of the Judge District Council Court in Miscellaneous Civil Appeal number 6 of 2017 and impugned order dated 26/7/2024 passed by the Court of Shri E. Garpo, Presiding Officer, Subordinate District Council Court, in title suit number 7 of 2020.
What's the matter about? What happened?
Your Lordship, initially, when the suit was filed, documents were filed, and thereafter, some documents were recovered by the petitioners at a later stage in the year 2011. Then thereafter, Your Lordship, we filed an application to allow, those documents were 2 medical certificates, and we filed applications to allow for admission of the 2 medical certificates. However, the learned trial court at that point of time passed an order whereby there is no specific order whereby the said application was dismissed. And then the learned trial court verbally informed that
Admitted.
verbally informed the council, me, that the said application was dismissed. Thereafter, I filed another application to vacate the order whereby the application was dismissed. Thereafter, show cause was filed by the respondents as defendants, but till date, Your Honor, there's no specific order regarding those 2 medical certificates. And these medical certificates are very vital, Your Honor.
You mean to say, when was the suit instituted?
In the year 2006, Your Honor.
When did you file your application for bringing in those 2 documents?
In the year 2011.
And then when were they supposed to be rejected? As per your submission just now, you informed. When were they rejected? Okay, when did you file your other application for recording the rejection order?
On 4th of July 2012.
2012. Yes. The matter has been hanging like that for
No, Your Lordship. Thereafter, what happened was, at that point of time, my junior counsel was working with me, the junior counsel was working with me, was directed to stress on the filing of the 2 medical certificates. But the said junior counsel, instead of stressing on the 2 medical certificates, had filed another additional list of documents dated 2nd May 2013. And that went on appeal when it was rejected by the trial court.
By the judge.
It went on appeal when it was rejected by the trial court.
Very complicated matter. Anyway, then after the 2019 order was passed by the judge, will you impugn that also?
Yes, I have impugned that judgment.
Yes. And what was the last order passed, which you're saying this is 24 order? What is it?
Your Honor, Your Lordship, by that order, the said title suit, which was originally title suit number 1A of 2006, renumbered as title suit number 7 of 2020,
Now you come.
was dismissed for default.
Now, why are you arguing the other points? Now you see this last order is that your suit is dismissed for default.
Yes,
Then you file for restoration.
Your Lordship, because it was dismissed in a very peculiar way.
Wait, 26 July, you have ample time to file for restoration of the suit.
I understand, Your Lordship, but
how can you take up the other matters if the root matter is gone? You have your grievances regarding admission documents, fine. But if your suit's been dismissed, this title suit number 7, 2020, renumbered.
Yes.
Then you have to restore the suit first.
Your Lordship, that's why I've come before this honorable court directly.
You want to restore your suit at the same time, look at the other applications also.
Your Lordship, because the way the suit was dismissed, if Your Lordship comes to, if Your Lordship allows me.
How was dismissed? Read the dismissal order. Simple. Plaintiff absent on step, defendants present.
Yes, that is.
The observer by its court, a plaintiff, despite numerous opportunities, has failed to take steps and has also failed to appear with court.
Now,
one indicator of the fact that means you don't pursue this case at all.
No, Your Lordship, that is not a fact.
But that's reflected in the order.
Yes, but prior to that date, Your Lordship, the matter was fixed on 19th of July 2024. In fact, this suit was fixed on 4 dates, just in the month of July itself.
Okay, we issue notice, let the other side have their say. Yes, I heard Mr. D. Thaba, Federal Counsel for the petitioner, issue notice returnable in 3 weeks. Steps to be taken by resident AD within 3 days. Yes, this also. Otherwise, if the suit is not default, we're not sitting in advisory capacity.
Your Lordship, because the CIS did not reflect that the suit was fixed on 19th, then it was reflected.
Problem with the even after putting them on CIS, they're not uploading the orders. What can we do? Yes.
Highly obliged.
Well, it's way before your lordships, Millets. What has happened is there's a certain school called the Rajabala School, Millets. Now, there are allegations, Millets, from numerous quarters that appointments have been made, Millets, for extraneous considerations. Now, in spite of that, Millets, what has happened is the state, Millets, does not seem to be taking any the matter with the kind of seriousness that it deserves. Because in as much as 2 members of that very managing committee, Millets, who was given the appointment, has also verified the fact that yes, there was some money paid by the private respondents, Millets, to secure that particular job. Well, it's starting from NGOs to students to parents, teachers, everybody's been filing complaints with the authorities. Then please look into this allegation because it's a very serious allegation. Unfortunately, still today, the government does not seem to be interested in verifying whether at all there is any merit in the matter or anything is there.
Okay, who are you, Mr. Paul?
I'm a guardian, My child is studying in that school, So if your lordships kindly have a look at my complaint, that is at page 35, in Annexure 3. And my name appears, at page 40,
These schools in this plain district, Mr. Paul, you don't know what to do, yes. Where is that? 35?
35, Annexure 3 is the complaint,
It's a newspaper.
35. I think is that some problem with the paging? May I request your lordships to kindly have a look at page 36 then, my lords.
So
I think
35 is corrected here.
35. It would be page 35. Well, this is addressed to the Director of School Education and Literacy.
When was this?
Well, this was filed on the 15th of July 2024. And my signature is, my lords, at page 40, the last signature, my lords.
Yes, Mr. Shulai.
May it please your Lordship. Lordship, my humble and respectful submission, your Lordship, and this is a defective writ petition. Kindly come to para 4 to 10, your Lordship.
Oh, yes.
Lordship, so many things has been said about the earlier proceeding, your Lordship. But
Yesterday also see para 11.
Lordship, then kindly see para 11, your Lordship.
Yes, that's yesterday it pointed out.
No, I'm coming to para 11.
Thereafter, consequential order. Read from there.
With the following composition, your Lordship. So many things has been said about the earlier proceeding order. Not even a single copy had been made part and parcel of the writ petition, your Lordship.
Well, these are narration of facts. These would not have
following composition, colon.
Well, it's with the following composition. I think that is a typo error.
Following composition.
It should have ended on 13/4/2021 to 13/7/2021 with the following composition, because the issue here is something that is absolutely different. I quite bow down that there are errors,
There has to be some form. Paul, I mean that
I bow down,
I mean, whatever it is, like, I know you're not personally, not personally supervise the drafting, but at least, there's some standard, like, there's some, we expect sometimes from some chambers.
I bow down, Militz.
There's some young juniors we can, condone or, but certain things, Mr. Thapa is sitting there with you. It is not your duty, it's been his duty to at least do some quality control.
Well, it's the difficulty these days is, with that control C and control V, that's...
Yeah, but then he has to have some quality control also.
He has to, Militz.
Stop, take down, yes, Mr. K. Paul, Leonard, Council also.
We have one respondent.
The informed petition as projected is with the functioning of the Rajabala Higher Secondary School, Rajabala. Rajabala is not Tura. Given the course title.
I'm sorry, Militz.
How no?
Rajabala is not Tura, no. Rajabala is Rajabala.
Under the management of the private respondents. Several allegations have been made, and also a copy of a representation filed before the respondent number 3 has been annexed in the representation stamp. Mr. Paul prays that notice be issued. Yes, in the matter. Next paragraph, Mr. N.D. Shulai, Leonard AAG, has raised strong objections as
1, 2, 3, launch.
For the 1, 2, 3 strong objections as to the format and the deficiencies in the petition. And has submitted that from para 4 to 11. The same is replete with omissions as to necessary documents which are referred therein. Next paragraph. He this court also notes the certain defects which are present in the petition, even a description of the in the course title with regard to the school. What should we do? You file a fresh one, Mr. Paul.
Would your lordships permit?
Let them approach their local Ayukta, Lordship. There is a allegation of corruption, your Lordship.
The petitioner is permitted to file a fresh petition, or in alternative.
Let that not fall from your lordship. If that is at all, it would reflect very badly from the state.
Citizens have problems to file a fresh. Yes, matters. Mr. People, then please, they will have to withdraw. Let's see if we file a fresh. Yes.
We'd make the necessary correction.
We have to maintain certain standards.
Absolutely. I bow down.
Oblige.
Reading this. Item number 1.
Well, may I pray your lordships kindly have this matter next week sometime, please.
Where's Mr. Sen?
There's no stay order, and I'm okay with that.
There's no interim orders.
It's a matter of after 2 weeks, a request from the Senior Council.
Right.
Your health is okay.
I'm okay with some family issues.
Item number 2.
Right.
Oblige.
I am entering my appearance from the substituted respondent.
Who is also respondent?
The legal of the
My
lordship.
The son of respondent number 3 and 4.
Yes, Mr. P.R. Paske, today, yes, in this case. Yes, Miss case number 2024. Mr. P.R. Paske, to enter appearance on behalf of proposed respondent. That is, what's your name?
Nogen C.H. Marap.
Nogen
C.H. Marap.
C.H. Marap.
Yes.
That's correct. On behalf of Nogen Marap, yes, who will step into the shoes of respondents number 3 and 4. Accordingly, the said Nogen Marap, according to this case, stands disposed of. On the main case, what do you want? In the main case, what do you want? Mr. Paske?
Yes, Your Lordship. I
What
may
do you
be
want
allowed
in the
to
main
file my reply.
Verify reply. In the main case, Mr. Paske, particularly the respondent, response allowed. Allowed how much time?
3 weeks, Your Lordship.
3 weeks. The name of Nogen, whoever shall be entered in the array of respondents. Let's say correction leave number registry. Just after 3 weeks.
Item number 3.
Deeply obliged, Your Lordship.
My lord, for respondent number 5, I'm praying for some more time. Union of India.
5 is whom?
Union of India. Border.
1 to 4.
1 to 4, my lord, we're waiting for rejoinder. My lord, we have already filed our affidavit.
Verify rejoinder.
Yes, Lordship.
Yes, Mr. The Dr. Musica please for allowed. Further, how much time?
4 weeks. 4 weeks.
4 weeks. Why?
But I've received instruction that it will take some time because the affidavit has to be vetted by the ministry. My lord.
Mr. Dr. Musica and Constable, please submit that 4 weeks further time be required as the affidavit has to be sent to the ministry for vetting. Praise allowed. Para MS E1M, praise that's below how much? Also, please further time to file a joint affidavit filed by respondents number 1 and 4. What about number 6?
6 won't be fine.
Just after 4 weeks. For affidavit by respondent number 5, the joined by the petition.
Item number 4.
May I please, Your Lordship?
Yes.
My lord, in this case, the learned executing court has passed the order for execution of the decree for the eviction of the tenant, but later subsequently stay the order, its own order. That's why I am here for this honorable court.
He's entering appearance today on behalf of tenant.
No, Your Lordship, actually not on record. I've only come on behalf of the respondent to request for a date because Jitu Bhattacharjee was seized with this matter in the trial court and the appellate court as well. He's not in good health. Hence, he told the respondent that I can't.
Are you entering appearance or not?
Sorry?
Are you entering appearance?
I am not, sir. I've just come to mention to be given a little more time.
It wouldn't work that way, Mr. Yadav, correct?
I understand, sir. But when she approached Mr. Bhattacharjee, he said, I may not take up the matter. And he was not available to come today. So I'm just assisting her in that regard. If 2 weeks were to
Assisting
give
whom?
Not assisting, sir. I'm just mentioning on behalf of the petitioner. Since Mr. Bhattacharjee is indisposed at present, Mr. Jitu Bhattacharjee, maybe given a little longer.
You've taken steps.
He has. We have received notice. She has received notice.
Oh, yes. Also indicates that respondent number 1 has since been served. Mr. What is your full name?
S.S. Yadav.
Mr. S.S. Yadav, whose present report has tendered a submission that though he is not representing the respondent, he prays that the matter be adjourned due to the ill health of the conducting counsel, Mr. G. Bhattacharjee. Is that correct?
Yes.
What to do? Let him engage on a counsel.
My lord, this case is fixed the day after tomorrow. The stay is for until further order. However, the case is fixed day after tomorrow.
Stay is by whom? By this court?
By
in your favor?
No, by the executive court stay its own order. Being agreed, I have come. But that stay order also until further order. However, the case is fixed day after tomorrow, 30. So subsequently order if any pass
after 1 week.
Yes.
In consideration thereof, it's a matter of 1 week.
Item number 5.
That's why you're trying to mention the matter in the morning. Don't do that. Yes.
Lordship, I thought it should come on the hearing. Sorry.
Yes.
Lordship, in 5, I've taken steps, Lordship.
Lordship, I'm entering appearance on behalf of respondent number 1.
Where's the Changreso?
He's having some personal difficulties today, Lordship.
Why is stopping the collection of violating the orders of this court?
Lordship, I'm praying for 2 weeks' time to file my
You do one thing, you instruct your clients. Not 2 weeks time, give 1 week's time to file affidavit. Otherwise, they'll go to jail. Yes.
Lordship, I must...
Must see one young standard appearance to be house for number 1.
Lordship, I must say that after we had filed this contempt, Lordship, the petitioner had gone to collect, was able to collect market tolls.
He's collecting now.
He's collecting now. Now the next market day is tomorrow, Lordship. The next market day is tomorrow.
No, in contempt,
Lordship.
You're entitled on behalf of all respondents.
No, Lordship, only on behalf of respondent number 1.
Who's respondent number 1?
Respondent number 1 is the same, Lordship.
Who's number 2, 3, and 4?
Lordship, 2 is the acting lingua, Lordship. 3 and 4 are his agents.
Ms. Iwanyang has entered appearance in behalf of respondent number 1 and prays shall be allowed 2 weeks' time to file affidavit. Service, as per the office note, service the other respondents is yet to be complete. When this is matter after 1 week, finally within 1 week or 2 weeks, after 2 weeks,
Come after 2 weeks.
by the respondent number 1 and parents of the other respondents.
Hello, Lordship.
Item number 6.
My lord, we are yet to file affidavit in this affidavit in opposition, my lord. On behalf of Mr. K.P. Bhattacharjee, my lord, I'm praying for some more time, my lord.
Mr. Keburaji he has some, I don't know what problem.
My lord, today Mr. Bhattacharjee is on a genuine reason, my lord. His son has met with an accident, so he has gone for medical.
I must ask only on behalf of Mr. K.P. Bhattacharjee, praise for the Lord. Wait for the affidavit.
My lord, I'm obliged.
Obliged, Lord.
Item number 7.
Please, Lordship. His Lordship, these respondents, state respondents have filed the affidavit. This matter can be disposed, Your Lordship, because they are not disputing. They have stated clearly that they are processing the pension paper. They said because of some documents or something, there was a delay.
Why we said that?
In the affidavit, para 7, they have make a clear statement, Your Lordship. So, Moreover, I have retired in the year of 2019. Now it's been about 5 years, Lordship. In the affidavit, page 3, para 7, Lordship, they have stated.
When can you do it, finish it?
Lordship, that AG also did not file the affidavit, Lordship. Because they are the
AG, Lordship, they are not the necessary
let
party.
that affidavit come, Lordship. Yes,
Lordship, once the state is directed, they will process, because this
Yes,
is
the affidavit has been filed on behalf of the respondents indicating the fact that the release of the family pension of the petitioners under process stop. However, the respondent before yet to file affidavit stop. Members EB Basa was present on behalf of number 4 phrase 4. Somebody said affidavit filed the course of the day. Lordship, this is matter of 1 week, yes.
Yes, Lordship.
You waited for so many years, you can't wait 1 more week.
Waiting, Lordship.
Number 8.
Yes.
What's the rest, Lordship?
My lord, here also I'm paying for time, my lord, to file the counter, my lord. On behalf of Mr. Bhattacharjee again, my lord.
2 weeks time is prayed. Very good.
Number 9.
Yes, Mr. Dr. Majika.
But I'm playing for some more time, Melvins.
No
What's the
objection.
matter about?
The pension matter, yeah.
Pension matter? Why dealing pension matter?
It's
Is it
about
DTA due to
denial of my pension, family pension, you're not sure.
how long?
Well, the unit is outside, matter 3 weeks time.
Which department?
BSF.
Yes, sir.
BSF.
When did he die? No, it's not a question of entitlement. No pension can be authorized. You're not authorizing a pension in Dr. Mosika prays for allowed for the 3 weeks time practice.
We apply.
Item number 10.
Like,
The affidavit is awaited from the respondent.
Lordship, I pray for some more time. Instructions are awaited.
Yes, the office law indicates that service not complete on sponsor 4 and 5.
Lordship, I'm appearing for respondent number 5, Lordship.
What about 4?
4, Lordship, the private respondent 4.
Afsha, Mr. S.E. Sheikh, the parent on behalf of respondent number
5.
5 is who?
5 is the...
Is the selected candidate.
Yes, her appointment has been challenged.
Yes, number 5. None of the service report with regard to respondent number 4 is not complete. The MSS Sham on behalf of 1, 2, 3. You also pray for time.
Yes.
And Mr. S.A. Sheikh pray for how much time? 2 weeks.
3 weeks, Lordship.
3 weeks affidavit. Gives her after for affidavit and for appearance of respondent number and for service report respondent number 4.
Right.
Item 11.
Lordship, I'm praying for 2 weeks time, Lordship, by the affidavit.
Lordship, this private respondent yet to see, we have taken a step to send the notice to the private respondent number 4.
Also indicates that service report on respondent number 4 a complete stop. Mr. H. Kharuk, please, for how much time?
2 weeks time.
2 weeks time for affidavit. This after 2 weeks for affidavit by respondents 1, 2, 3, and for service report on respondent number 4.
Lordship. Most blessed Lordship.
Item number 12.
Time.
May it please your Lordship. Lordship, the grievances of the petitioner is being looked into by the department, so we need some more time, your Lordship.
What's the matter about?
This is
Welcome retirement gratuity.
People of gratuity.
enhance GCRG, your Lordship. It's being looked into, your
Why affidavit?
3 weeks time may kindly be allowed, your
Why
Lordship.
3 weeks? Mr. Indishulai, please, for please, for 3 weeks time.
3 weeks, yeah.
After instance.
Apply, your Lordship.
Applied. 13.
May I please, your Lordship. This matter, Lordship, with regard to the school, my Lord. With regard to the inserts appointment of headmaster of the school, my Lord. My Lord, we have taken steps to the private respondent, my Lord, on 19/8, my Lord.
My Lord, I am appearing for the private respondent, my Lord. Yes. Mr. SD has entered appearance on behalf of the private respondent number 4.
My Lord, today is
One
fixed.
second. And such notice complete. Yes. There, what do you have to say? Instruction.
We're still waiting for the instruction.
You want instruction?
No, yeah. Not full instruction. Not full instruction.
What do you mean not full instruction?
Some department hasn't. Some department is still yet to.
Yes, what do you
My
want to
Lord,
say?
this matter is fixed for hearing on interim hearing, my Lord, on the interim prayer, my Lord.
Okay.
My Lord, the impugn order was issued by the director.
Where's the impugn order?
My Lord, at page, my Lord, at page 45, annexure 9, my Lord, issued by the director of school, my Lord.
Yes.
My Lord, my first argument with regard to this, my Lord, the director of school has no power, my Lord, to issue this impugn order, my Lord, because the appointing power lies with the managing committee in this kind of schools, my
The
Lord.
deficit school?
Yes, my Lord.
The deficit school or
No, man, it's ad hoc granulate school, my lord. In ad hoc granulate or maybe SSA or maybe a deficit schools, now power of appointment lies with the managing committee, my lord. Government is only merely the approving authority, my lord. So the director of school, my lord, has exceeded his jurisdiction, my lord.
on what basis was this order passed in?
My lord, that only the government has to.
My lord, the order was passed. The date of appointment of both the teacher was on the same day, but the approval was given prior to me, then him, my lord. There is 3 days difference of approval. State has given me the approval, then my post was approved, my lord. And then his post was approved. That is why, my lord, I become a senior of 3 days, my lord. That is why this.
And age-wise, who's more senior?
I'm senior, my lord, in age. Yes.
No, my lord, the then managing committee in 2005 had prepared a list of teachers, my lord, which I have annexed, my lord, in my written
Let me
petition,
file
my
a
lord.
small affidavit to his
One second. Here, what is to say that this.
And my lord, the managing committee has constituted and submitted before the SDSCO, my lord. In the managing committee meeting, they have anonymously resolved and decided to the petitioner as the convener, my lord. That is pending before the state respondent. That may be disposed of. And the CRC,
affidavit.
yes, my lord.
Yes.
CRC and BRP, the government officials are
the
present,
newly
my lord.
period, Mr. SD, who has entered appearance today, is on behalf of number 4. So, praise that he be allowed 1 week's time.
10 days, my lord. Since government is 10 days, I will file. 10 days will.
10 days time to file a short affidavit before the prayer
in the miscase.
for the
My lord,
hearing interim prayer.
interim prayer, my lord.
I'll file my application, interim prayer.
This after 10 days. It is expected in the meantime that the GA also comes up with specific instructions.
14.
Hello.
Highly obliged.
Yes.
May it please, Your Lordship. Your Lordship, I'm praying for some time, Your Lordship.
Yes?
I'm praying for time, Your Lordship, to file the affidavit on behalf of respondent 1, 2, and 3.
How much time? 2 weeks.
3 weeks, Your Lordship.
Any urgency?
No, Your Lordship.
3 weeks for the time it's prayed. Not to the state council, to the GA to file after on behalf of the respondents.
Hearing? Obliged, Lordship. Hearing 17. 17.
Where's Mr. Ready with the matter, correct? Ready with the matter. You ready, right? Very good. Yes.
Your Lordship, this I'll be challenging the impugn order dated 15/11/2022 passed by the CEM of GHADC, Your Lordship. 15/11/2022, Your Lordship.
Where is it? Page?
That is page 65. Page 65, Annex 10.
Yes.
They just made an order. No, my lord, they hear the case of the petitioner here is, Lordship. This petitioner is a Nogma, then there is one Dalibokri Akeng. This particular Akeng was in existence since from 1948, my lord. 1948. Thereafter, the separate, their existence of separate Akeng was in existence, and there was a separate Nogma, your lordship. Now, in the year of...
Before my friends start, my lord, the matter, I think the record will be required, my lord.
Record not with you?
No, the record has not been called, my lord, yet. So, if record...
Well, usually you have them with you.
Yes, but this time, my lord, they have sent me the parawise comment, I have not filed it. Means I have not asked also them, my lord. Affidavit is already filed.
Correct?
Affidavit is already filed, but record, because the allegation has to be ascertained from the record also, my lord. 2 weeks.
On limitation?
Yes.
This is actually only the case is on limitation. The only two questions.
How long was the delay?
It is 9 years, my lord.
9 years only?
9 years. It is total number is 3,590 as per the statement is given in the statement. Total delay of 3,590 days. Now, yes. Now 3,590.
590 days. Okay.
Lordship.
Now, the order you appeal against is dated when?
That is on.
Order of the
yes, that is on 24 February 2010.
24
02
2010. You file appeal on?
File appeal on 4 December 2019. 4/12/2019.
Yes.
It's about 9 years.
Then where's the need for records, Mr. Day?
Even
if the act not applicable, also it's on a ground reasonableness.
But my lord, I would like to just ascertain myself whether these many days is really exactly there or not. Give me only 1 week time, my lord, or 10 days, my lord. I will ascertain and I will take the instruction.
How did you file this after? Why did you file it after 3,590 days? Why?
No, they have filed it before the CEM.
He is agreeing with this order, my lord. That is why I am seeing the record. It's not that because
he's the opposite party there. Why you agree with the order of CM?
Because he is agreeing with this order.
No, they have allowed this continuation of delay.
Was allowed?
Yes, because
I was ministry. Yes, I thought it was dismissed. Yes, at the start of the hearing, Mr. SD submits that the records of the proceeding before the EM in charge revenue and CEM and S3 for proper education. Only call for the records of the proceedings from the DHADC. Yes.
2 weeks, my lord. I'll pray for 2 weeks.
Or because with no, you don't say that. Nothing necessary, sir. Mr. undertakes to produce records and an author of the records. Seen that so unnecessary. Next paragraph, Mr. SD undertakes to produce reports the next day. Now, according to the matter of 2 weeks, yes.
Well,
So it's lost.
18.
I'm praying if this matter can be taken up next week, Lordship.
You requested for this date last week or on 7th?
Lordship, some difficulty, Lordship, today. Lordship.
You ready?
No objection, Your Lordship.
You ready to the matter? You ready? After 1 week, due to personal difficulty of Mr. Chanda, for response number?
8, Lordship.
8.
4 to 8.
4 to 8.
All right.
21. Twenty-one.
But please, Your Lordship. Lordship, this is a case where I am seeking for retrospective regularization, Lordship. My post was regularized 2018, Lordship, whereas I was appointed in 2004, Lordship, on compassionate ground, Lordship. My case is that I should be regularized from the date of my appointment, Lordship, since it is a case of compassionate appointment. Lordship, here the petitioner's father was working as office assistant in the office of the respondent, Lordship.
Yeah.
His father died. While in service, the petitioner's father died on 29/7/2004, Lordship.
Okay.
After the demise of my father, Lordship, then 5th of August 2004, Lordship, I was appointed in the same post, Lordship.
After he died 29/7/2004.
27,
and
29/7.
within a few days you appointed again.
Yes, Lordship.
How? Ad hoc.
This is of officiating, as an officiating capacity.
5th of August 2004.
My appointment is at page 10, Lordship.
Okay.
May I read, Lordship? That Sri Joni Marbo, son of late so that attendant is hereby allowed to officiate as attendant in the establishment of disease investigation officer, AH and veterinary Shillong in the pay scale of so-and-so, plus other allowances as admissible under rules for a period of 2 months only with effect from the date of joining.
Yes.
After that, Lordship, I was continued. Then when my post was not regular as Lordship, despite my efforts,
Yes.
then I had approached this honorable court and filed a writ petition, Lordship, for regularization. My Lord will find page 11 is the order.
Yes.
My Lord, I'll read the only 2-page order, Lordship. I'll read the entire order, Lordship. The case set up by the petitioner is that the father, late Lal Mal Soma, was working in grade 4 in the office in the respondent department but died in harness on so-and-so. The petitioner represented for being appointed on compassionate basis. By office order number so-and-so issued by the Director of H and Veterinary Meghalaya Shillong has been allowed to officiate as attendant in the establishment of disease investigation officer H and Veterinary Shillong in the pay scale of so-and-so with for a period of 2 months with effect from the date of joining but is still continuing till date. The petitioner seems to have represented before the responding authorities for permanently absolving him. Same has not happened, hence this instant petition. The petitioner was entitled to compassionate appointment in terms of office memorandum number such and such issued by the government of Meghalaya. Instead of giving him regular compassionate appointment in terms of the said OM, has been engaged in a regular pay scale to officiate only for a period of 2 months. It is not understandable as to why the order was conditional one for a period of 2 months, that too without mentioning on compassionate basis. Now there is a later development, that is fresh notification has been issued on 2/12/2010 by the government of Meghalaya in terms of thereof. Scheme for employment of compassionate ground as provided under the OM number so and so has been abolished with effect from 24/11/2010 with a condition that only pending proposal including those arising up to 24/11/2010 will be examined on merit by the government. The contention of the learned counsel for the respondent that the compassionate scheme governed by OM dated so and so has been abolished, therefore the case of the petitioner cannot be considered. The notification abolishing the compassionate appointment scheme dated so and so protects the position of the petitioner. The words employed, that is only pending proposal, including those arising up to so and so will be examined on merit by the government, takes into sweep the case of the petitioner because the petitioner in effect has been engaged on compassionate appointment. In effect, his case is pending for permanent absorption. The notification dated so and so has no adverse effect on the rights of the petitioner because he has been continuing working with the respondent department right from the month of August 2004. That is immediately after the death of his father in harness. At this stage, his right for permanent absorption, subject to fulfillment of other requisite conditions, cannot be denied. Appointment on compassionate basis is the department from normal appointment. The logic and object of such appointment is to save the family of the deceased employee from financial crisis. The scheme has a laudable object of protecting the family from financial hardship. In effect and in principle, the petitioner has been granted the benefit, but unnecessarily with a condition which condition by itself is then diluted because the petitioner has been continuing now for the last more than 14 years. Now this is the direction, Lordship. In the stated facts and circumstances, right of the petitioners cannot be allowed to be jeopardized merely on the dictate of the respondent authorities. Unnecessarily, the petitioner has been subjected to mental agony and to unwarranted circumstances. Therefore, the petition is disposed of with a direction to the respondent to accord due consideration of the case of the petitioner for permanent absorption as against the post he has been working right from 2004. The engagement of the petitioner being in effect on, this is very important, Lordship. The engagement of the petitioner being in effect on compassionate basis, so requires no further elaboration. The respondents, after considering the case of the petitioner, shall pass appropriate orders regarding his permanent absorption within 2 months from today. Since my appointment on compassionate ground, looking into consideration the source of my appointment, direction was given to consider my case for permanent absorption, Lordship. Now, Lordship, in terms of the order, Lordship, in pursuance of the order, Lordship, they have, Lordship, they have regularized my post, but prospective regularization was given, Lordship. That is at page 14, Lordship.
Yeah.
That in terms to government letter number so and so, dated so and so, Sri Joni Marvo presently officiating as attendant by this office order number so and so. That is my appointment order, Lordship, 5 August 2004. Is hereby absorbed in the same capacity under the establishment of Assistant Director, Disease Investigation AH and Veterinary Department, Shillong. His appointment is hereby regularized with effect from the date of issue of this order, Lordship. Now, what happened, Lordship? I have been subscribing my GPF, Lordship. My Lord is way aware that GPF is only applicable for the government servant. And I have been subscribing the GPF ever since my appointment in the year 2004, Lordship. Now, Lordship, after the passing of the order, Lordship, till date, Lordship, I am subscribing the GPF, Lordship. Now what happened, Lordship? Now page 15, Lordship. Page 15, Lordship will kindly serial number 4, Lordship. These are the compassionate appointees, Lordship.
Yes.
Their regularization was given with effect from the date of joining, Lordship. Serial number 4, serial number 5, Lordship. In the remark side, Lordship, those who are appointed directly, Lordship, through proper channel, then they have to, their service was regularized after they, regularized by the DSC, Lordship. But so far as serial number 4, 5, Lordship, the cert is given, Lordship, the date of joining, because their the regularization was effected from the date of joining, Lordship. 6, 7, 8, 9, Lordship, 10. Then next page, event 15, Lordship. He joined 2008.
Yes, you wanted to show by this one that they were, you want to show that they were given retrospective regularization?
Yes, Lordship.
How? Where did it say?
Your Lordship, kindly see date of joining and date of regularization by DHC and others in the column, Lordship.
96. 1 year, date of joining is not the same. 1/7/1999.
No, Lordship, if my Lord will kindly
90. This and this
paragraph
one.
4.
Oh, sorry.
Serial number 4, Lordship.
Number 4.
4, Lordship. His date of joining is 24/5/2002, but date of regularization 15/5/2002, Lordship.
Date of joining is regularized. Similarly, here also, number 5.
Same, Lordship.
Before the date of joining, they've been
Regularized, Lordship. Even 6 also, Lordship.
Yes.
Now, Lordship.
You petitioned them.
Pardon, Lordship.
You filed representation.
Yes, Lordship.
What happened?
Now, Lordship, in 2021, Lordship, they made another the gradation list, Lordship. Final gradation list, that is at page 18, Lordship.
Yes.
Here also, Lordship will find serial number 4, Lordship.
Yes.
Date of appointment is column number 4, 2008, and date of joining is 2008, and date of regularization is 9/2/2009. And down below also, serial number 5. Date of joining is 2009, and date of regularization is 2009.
Where is the representation? What is the answer?
There is no answer, Lordship.
Yes, Mr. Karan.
My Lord, I'll just...
Why don't you give equal treatment to him also?
If my Lord will kindly see page 23 also, Lordship.
That's a very old notification.
No, Lordship, 23 page 23, Lordship.
Yes, 23.
23, Lordship.
Yes.
Now here also, I am the similarly situated, Lordship. Now they, although they have been regularized in the year 2022, but their regularization was made with effect from 2007, Lordship.
Where does it say? Okay.
This letter is also, my Lord, is with effect from 29, with effect from 27
Yes,
2000.
Yes. Yes, Mr. Karan. Yes.
Lordship, may I? Lordship, may I take the Lordship to the prayer in this matter? At page number 8, Lord, or page number 9. May I read, Lordship?
Number 8.
Lordship starts from page number 7, but it goes to
Okay.
page 8. In the premises aforesaid is humbly pray that your Lordship may be pleased to admit this petition, issue rules, and upon hearing parties, your Lordship may be pleased to quash, modify, or set aside office order dated 22/10/2018, only to extent of giving prospective realization of the services of the petitioner, and may further be pleased to direct the respondents to effect realization of services of the petitioner from the date of joining, that is...
It's a typo.
Lordship. Lordship, basically...
See what you written here, Mr. Sheikh, in your prayer.
My Lord...
Top, you see, quash more and to the extent of giving prospective realization.
This type of Lordship.
Okay, yes.
My lord, only to the extent, my lord,
Well, yes.
my lord will kindly appraise. I am not agreed by the regularization. I am agreed only with regard to the prospective.
That way, that you only, you set aside only the extent of giving prospective.
Prospective regulation.
Given prospective regulation,
Yes,
you're not
Lordship.
aggrieved.
I am agreed by that prospective.
But prayer does not reflect that. Anyways, it's just how you structure your.
And my lord will kindly and further will please to
Yes,
direct
okay, yes. What do
the
you-
respondent to effect regulation.
Yes.
Lordship. Point number 1, Lordship. Point number 2, Lordship. Can I take your Lordship's page number 13 of the
Page
direction?
13?
Lordship, of this High Court's judgment, Lordship. The direction, Lordship, at paragraph number 8. May I read?
Yes.
It is stated facts and circumstances, right of the petitioner cannot be allowed to be jeopardized merely on the exit of the respondent authorities. Full stop. Unnecessarily, the petitioner has been subjected to mental agony and to unwanted circumstances. Therefore, petition is disposed of with a direction to the respondents to accord due consideration to the case of the petitioner for permanent absorption as against the post he has been working right from the year 2024. The engagement of the petitioner being in effect on compassionate basis requires no further elaboration. The respondent, after considering the case of the petitioner, shall pass appropriate orders regarding permanent absorption within two months. Lordship, there is no direction that that petitioner shall be absorbed on compassionate
Okay, only
basis.
one
Lordship,
thing
this is
now.
because as per the order which was recorded in the
Sorry to interject.
Lordship.
But in other similarly situated situations, employees, you've given them respective recognition from the date of the joining. And why are you singling them out to not give the same kind of benefit?
Lordship, that
what is the reasoning behind that?
Lordship, that's not the case of the petitioner, Lordship, because he has not. If he has to implead these people so that they can also, because right now, Lordship, if I may, Lordship, if I can take your Lordship to page number 15, where the petitioner has pointed out the cases, Lordship.
Yes. Yes.
Lordship, point number 4.
Yes.
Sri Shelba Norum Bull attendance Huvansu, date of birth 1982, date of joining 2002, and the date of notification, Lordship. If your Lordship can see, the date is 15/05/2002, Lordship.
Yes.
That is before the date of.
The court has seen that, but whatever it be, maybe the order came on that date, and they joined only 9 days after that. That's perfectly all right. 15 days for joining is always given to
Lordship,
employees, yes.
if I can bring your Lordships to the notification dated 2nd December 2010, whereby the compassionate appointment has been abolished, Lordship.
Have been?
Abolished.
No, that's fine. No. See, the thing is that, is it correct that you appointed him on a compassionate ground? What have you said in the affidavit?
The affidavit is
The
very vague.
appointment, was the appointment on the basis of the standard form for compassionate appointment?
The affidavit is very vague, Lordship.
No, Mr. Sheikh, when your petitioner applied, wasn't standard form for compassionate appointment under the scheme? You see, prior to 2011, there was a scheme which was prevailing.
Yes, Lordship.
And under the said scheme, there's a certain, how requisites, how you're going to file it also.
That is why
So whether that was complied with or not.
But that is not the issue they have not raised also.
No.
My Lord,
It's not a question. Their weakness will not, fortify your case. The thing is that now, for a compassionate appointment to be considered as per the scheme, there are certain requirements. If I correctly remember, you have to give your financial certificate issued by the Deputy Commissioner. Other things also showing your distress. And on those grounds, usually it's processed and maybe afforded some appointment. Or if the case maybe you don't need it, not give it. So in this case, only court wants to know whether at the time when he entered employment, whether he had filled in the requisite form
My
for
Lord,
compassionate appointment, and whether on that basis ad hoc appointment was given to you. If that's the case, then there's no quarrel. You'll be entitled to regularization from the date of your joining. But if that's not the case, then you just accommodated somehow, and later on you came, and it's been fashioned into a compassionate ground appointment, then maybe your case will be in the same footing as the other people you showed.
now what will happen, Lordship? I appreciate one thing. As on today, I am subscribing the GPF as on today.
I'm not going there.
Now,
We're not going there.
Yes,
We're not going there. What this court wants to know is whether,
True, Lordship.
at the time you entered employment, how was it? It's just appointed just like that on the regular.
My Lord will kindly appreciate one day I was appointed just after 5 or 6 days, Lordship. May not, prior to my appointment, I have to consider, may not.
So then
my Lord,
then,
maybe after.
Then what was, the duration just shown?
Yes.
Compulsion not apply to you then.
Then after my appointment, Lordship, I have to take instruction. After my appointment, that all formalities have been fulfilled. That is why, Lordship, I was asked to subscribe the GPF because I was constituted as a
You have
government
any materials to show that it is done?
Pardon?
You have any materials?
Pardon, Lordship?
To show that you subscribed GPF?
Yes,
You
Lordship.
submitted a form subsequently?
Yes, Lordship.
Where is that?
If I think
I'll have, Lordship.
If I can take my Lordship.
Meaning in the writ petition, where is it?
I didn't because I have made the pleading, but I didn't annex, Lordship. My only thing is the Lordship, if I am given that prospective regularization, Lordship, I'll be.
The thing is that, see, whatever rights you have or whatever rights, it stems from your appointment order and your terms of appointment or your terms of engagement.
Yeah, yes.
If for the term of engagement, you can see that, yes, sir, you're vested with certain rights. But everything, appointments and everything is from the basis, where do you derive your right from? That's the only thing.
My Lord.
You derive your right from your initial appointment order. What does it say? And under what terms you appointed? The court examines that. Service matters is not so difficult.
Yes, true, Lordship.
It's only that you look at, you look at the basis. All.
And if
you start from there and you go forward. And whatever has happened has gone here, gone there, then you can correct it. If there's something wrong, then the court is to correct that.
True, Lordship.
That's all. And if you don't derive any rights from the initial appointment order, then.
My Lord, even the 1978, that notification, Lordship, my Lordship has referred that notification in several judgment, Lordship. I am relying that judgment also. Just recently also, this year also, my Lord have passed some judgment. And one judgment, Lordship in 2019 also, referring that 1978, because that 1978 notification says that my past service, whether it is officiating or temporary.
Then that's not compulsion ground. If you go to 17 memorandum, that's different. Memorandums issued subsequently. If you go to that 17, that means you're claiming your right only as ad hoc.
Yes.
Or 3F. That's all. Then which board you want to seal in?
No.
You want to seal in the compulsion ground board or you want to seal in ad hoc?
No, my appointment, my source of my appointment is on the basis of compassionate ground, Lordship. Yes.
Then now you want to 78, that's on the basis of ad hoc appointment.
Now they are saying that no, officiating. Even if presume that I am officiating.
You can't take that ground now. True. If you're on the compulsion ground, stick to it. Stick to it, then 78 is not in the picture
True,
at all.
Lordship.
Yes.
I'll provide the details of the
What do you provide?
GPF, Lordship.
Where is the common land?
Lordship, I can take your Lordship to page number 14. Of the petition, Lordship.
40?
14, 1-4, Lordship.
Or 1-4.
Lordship, as per the office order, Lordship, he has been appointed or recognized from the effect of issue of the order, Lordship.
Go to the source of when you have the records of his appointment.
Records of his appointment, Lordship. Prior to the regularization, Lordship. Lordship, that I don't.
Not prior. I mean, how he came into employment. No record to maintain.
Lordship, that I have to check, Lordship. But then the issue as of right now, Lordship, is he wants to have a appointment with a retrospective effect, Lordship.
I don't see what he's doing is that his first line of offense is commercial ground, but second line of defense is that ad hoc appointee. So that's the thing.
Lordship.
But you see that order of the with due respect to the earlier coordinate bench also, you see.
Lordship, also number 3 point, Lordship. This petition is barred by the legal access, Lordship.
The thing is that see the observation, the engagement of the petitioner being in effect on compassionate basis.
True.
In effect, there has to be process. If the process is there, it has to be followed. You probably would want to do, but even then, it's not given that you'll be allowed if your terms of appointment are such. Yes, sir. This.
It is not a case that I am working in a non-sanctioned post, Lordship. I am working in a sanctioned.
No, don't go there, Mr.
Yes,
Sheikh.
Lordship.
These are standard arguments you make, like if we, what with on other cases, non-sanctioned post or sanctioned post. We're not there at all. The thing is that now we only need to examine if whether your appointment was on compassionate basis.
Yes.
That's all. You don't have to recall. Where's the affidavit? You've not seen it also.
Lordship, it's Lordship, my affidavit, I say that the petition is barred by delays largest, Lordship.
See, no, see, 6 they said that. It is officially with and not on compassionate ground. Yes. And that you have to meet that, yes.
Lordship, paragraph 7, Lordship, I stated that he is not appointed on compassionate basis, Lordship, and Lordship, accordingly, Lordship, the petitioner has also accepted the ground, Lordship.
Employee.
Lordship, if I can may read my paragraph 7, Lordship.
Yes.
Lordship, that in reply to our woman's main paragraph 14 of the petition is submitted that OM number or dated 11/12/1984 will have no bearing in this case, and the same is inapplicable to the petitioner since the same speaks about compassionate appointment. Whereas the petitioner was initially appointed on a eating basis.
He's not been able to make a case.
But in Lordship,
it's just banking on the earlier order.
If Lordship may hear me for a bit, Lordship, even the petitioners agreed to this thing. Lordship, they haven't filed any rejoinder, Lordship. Hence, they have agreed to the submission, Lordship.
This is on record, Lordship. Whether I was appointed.
Why, if you're against 18, why you came 23, 5 years? So you're quite happy that time when you arrived in 2018?
No, Lordship. When my gradation list was published, Lordship, since my lord from the date.
No. You can't take that submission.
My lord,
the thing is that now in 18 that regularization order was given to you, correct?
Yes.
You were regularized. Now why didn't you come immediately to court thereafter?
Lordship will kindly appreciate one thing. Till date, Lordship. Till date, I am subscribing the GPF.
Nobody GPF.
Yes, true, Lordship.
I was of
the view that, Lordship, that I will be governed, Lordship. I will be governed by the old pension scheme, Lordship. No, when I, Lordship, approached to the department, they are saying that no, I will be governed by the new pension scheme.
Yes.
Yes, new pension scheme. But till today, I am subscribing. But the order did not specifically mention that yes, in view of the regularization with prospective effect, that you will be governed by as per the new pension.
My lord, the submissions made by my friend right now is beyond pleadings, Lordship.
Yes. We realize that. Beyond pleadings. Now you're coming in PS and your old pension scheme.
Yes.
Then, and why did you come after 2018 order was passed, you observed? Why did you come in 2023? That too on the month of?
My lord, 2021, the gradation. Yes, Lordship. 2021, the gradation list was published. In the gradation list, Lordship, I am not against the gradation list, Lordship. I am not challenging that I should be given that seniority list. That is not my case. My only case is that I should be governed by the
whole case. Exactly. Is that, Mr. Sheikh, it's a bit tricky your case because there's no compassionate ground appointment. It's only an order of the courts is in effect. In effect, this compassionate ground doesn't make it a total compassionate ground.
Maybe his Lordship, the submissions made by my friend right now is regarding the gradation list. If he doesn't have anything with regards to gradation list, he doesn't make sense. Because right now he's questioning the appointment order, which he could have questioned.
You have come at that time only.
Lordship, I have a judgment which says that laxity of the petitioner in approaching the court will not.
My lord, the delay and lapses will not come into play, Lordship. Why I am saying I am not seeking any pensionary benefit. I am not seeking any that past area due, Lordship. This is only the thing is that if prospective, then I will be governed by the new pension scheme, and if it is retrospective.
But where have you made the pleadings in your case regarding a new pension scheme?
My lord, that is why I have challenged.
Submissions beyond the pleadings, Lord.
Mr. Sheikh, what do you agree with? You be clear with that. Then court will try to address. We can't go with all conjectures and surmises. Yes. You prepare again, otherwise you know what the mind of the court. Yes, just after 1 week, you allow the petitioner to produce added materials in support of it.
23.
Hello, Lodge.
Yeah, what's the matter about? Yes.
I put the respondents, Your Lordship. The petition essentially seeks employment in lieu of allotment of
Petitioner
land.
is here, so petitioner can start.
Yes.
My Lord, the petitioners in this matter, they are members of the Kharkongur clan, my Lord.
Yes.
And the petition that the petitioners have placed before my Lord, it raises a very simple issue, my Lord. It raises an issue of Article 14, equality, my Lord.
Okay.
In a sense, that is the broad issue, my Lord. Now, how and why the Article 14 issue is being raised, if I can just take a few minutes to explain that. Lordship, as I mentioned, petitioners are members of the Kharkongur clan. In 2015, my Lord, the clan was approached by the respondent corporation, page 24, for grant of certain land to set up their power plant, etc. This was 2015, February 3rd February 2015. Subject was requirement of land for so-and-so substation at Smith. So this was the request in February 2015. The clan discussed the matter and the request was agreed, next page, my Lord, 14th May 2015.
Yes.
So the clan had discussed and the clan agreed to grant whatever was required, the land that was required to the respondent corporation, my Lord. As a consequence of this grant, page 28, my Lord.
28.
28.
Yes.
A patta was also executed by the clan in favor of the respondent, my Lord.
Yes.
This was patta, my Lord, was in the same year. No, this was 22nd March 2017, my Lord.
Okay, yes, then.
Now, Lordship is aware that when land is given by clans free of cost, there is a system of employing members of the clan into the concerned department. Appointment, my Lord, finally took place at page 31 on 2nd July 2020.
Yes.
Petitioners, my Lord, are placed at 53 and 54 of this list, my Lord.
Okay.
And it's required for me to petitions, two petitions, my Lord, 53 and 54.
Right, okay.
Also, my Lord, it's required for me to
appointed on
2nd July 2020.
Yes.
Also, my Lord, it's required for me to point out humbly that if Lordship looks at the first paragraph of this order, it was a appointment on contractual basis.
Yes.
In pursuance to the office order number so-and-so, dated so-and-so, the following persons are engaged on contractual basis and are hereby posted in, it goes on. So the appointment was on contractual basis, page 33, my Lord. Page 33 is a sample of the contract that is entered into year on year, year after year, with the petitioners, between the petitioners. 33, my Lord.
This is, okay, right.
So this is the contract that is entered into year after year between petitioners and the...
You mean to say the police, they've been working all along till date?
From 2020, they've been working.
Till now?
On contractual basis, my Lord. On contractual basis. However, my Lord, page 41 may be looked at.
Yes.
Now, page 41 is the office memorandum of 2017, which is, I would say, the fulcrum on which this case is turning. 30th August 2017. And I'm certain Lordship is very familiar with this memorandum. This is the memorandum through which the scheme of appointing clan members in lieu of grant of land was formalized. I'll read, my lord. The second portion, amendment of para 7, my lord. Now, this scheme is in two parts, my lord. In case where private landowners, so the first part concerns private landowners. In case where private landowners have donated land free of cost for government purpose, the land proposed to be donated should be legally handed over through a registered deed to enable the government to provide appointment to any persons as recommended by the landowners in a grade 4, grade 3 post. Second part, where land is donated by the Nokma, CM, Doloi, Ride, clan, etc. Then the Nokma, CM, Doloi, Ride, clan, Sardar, as the case may be, shall identify the appropriate person or persons in consultation with the affected families, if any, to whom appointment can be given. The Deputy Commissioner of the concerned district will identify the post. It goes on, my lord, it goes on. We are concerned, I would humbly submit that we are covered under the second part because land has been given by a clan, my lord. Now, land being given by the clan, the only requirement...
Will land be government purpose or for... Because you're having a dealing with the commercial entity.
Lordship, I'll address that issue. So I'll address that issue. Lordship, as I was submitting, that the second portion of the scheme, that will be the portion applicable to us because this is land given by a clan. Now, when land is given by a clan, as per the second portion, the only requirement is the head of the clan should identify the people who according to him should be appointed. So petitioners were identified. Petitioners were identified by the head of the clan, but there was for a long time there was no formal appointment. The only appointment we received was contractual basis. Now, contractual basis is not what is contemplated by the scheme. It should be at least grade 3 or grade 4. Matter was in limbo for quite some time. We kept on requesting the corporation. There was no movement from the side of the corporation. In the meantime, an interesting and an important development took place, my lord. Page 44. Page 44 is an office order of 11th June 2020.
Yes.
Now, Lordship, the dates are important. Lordship will kindly recall my petitioner's appointment was on 2nd July 2020. This OM office order is about a month prior to that, on 11th June 2020. Now, I'll read this office order, my lord. In line with the, and this is issued by the respondent, my lord. In line with the office memorandum number so-and-so dated 30th August 2017. This is the scheme which I had just pointed out. In line with that particular scheme issued by the Personnel and Administrative Reforms Department, Government of Meghalaya, the following persons are hereby temporarily appointed to the post in the scale of pay indicated against each plus other allowances as admissible under the corporation's rules and orders, etc., etc. My lord, 20 persons were appointed prior on a temporary basis, meaning, in other words, that they were entitled to, besides their standardized salary rate, they were entitled to other claims, other benefits, etc. They were appointed on a temporary basis based on the same 2017 scheme or memorandum. 1 month later, I was also appointed, but my appointment was of a completely different nature. So,
yes, you see, you're appointed on a contractual basis.
On a contractual
right.
basis, which doesn't entitle me to any sort of benefit or permanency or guarantee. So, therefore, my lord, I'm confident Lordship would have identified the issue already. This is the issue, my lord. I'm seeking parity with persons who are similarly situated. As part of that, I've sent multiple representations. The Principal Secretary, Government of Meghalaya, has also written to the department concerned. There's been no response. Many legal notices have been sent, my lord. Reminders have been issued. However, my lord, till date, there's been no response, constraining the petitioners, my lord, to stand before this honorable court today. Now, against the writ petition, affidavit has been filed. A very interesting stand has been taken in the affidavit, my lord. Now, as lordship would have seen, our point is very simple, my lord. Our point is that the scheme of 2017, the memorandum of 2017, entitles us to be appointed in a certain manner. We have been denied that sort of appointment, whereas 1 month prior, you have already implemented or applied that scheme, that memorandum of 2017, to appoint 20 other persons. Now, in their affidavit, the respondents have attempted to distance themselves from that 2017 memorandum. How they have managed to, or how they have attempted to distance themselves, there are 3 or 4 broad reasons they have given, 3 or 4 broad grounds. The first ground that they are adopting to try and distance themselves is that, according to them, and this is what had flown from lordships, from the bench also, according to them, they are a respondent, they are a corporation. So therefore, the scheme or the memorandum of 2017 pertaining to government departments does not apply to them because they are a corporation, my lord. Lordship, with all due respect, against this stand, against this ground, I would humbly submit, firstly, that it is too late in the day to contend that they are not part of the state, my lord.
Yes.
I have brought it out in my rejoinder also, at para 4. I will not take up too much time by opening para 4 of the rejoinder, where their shareholding is 100% owned by the government. Their own directors' report tabled at the AGM call themselves a government company. So therefore, to say that we are a corporation, therefore not a government, as I said, it may be a little too late in the day to contend that, my lord. More importantly, this attempt of theirs to say that they are a corporation, therefore 2017 memorandum does not apply, will not stand in view of the position that they have adopted in a fairly similar litigation that was concluded some time back, and judgment was passed by a coordinate bench, my lord. This is MECL Progressive Workers Union versus MECL, Meghalaya Energy Corporation. This judgment has been in the news for quite some time. Now, in this judgment, lordship may be aware, it's regarding a slightly different aspect, equal pay for equal work. But however, an incidental issue arose in this judgment, in this case also, as to that 2017 scheme, that memorandum, and the appointment of 20 persons, which I just highlighted. The stand taken by the corporation, by the respondents in that other litigation, is at para 27, my lord.
Of the judgment?
Of this July judgment, my lord.
That's page, internal page number?
Internal page 1818, my lord, para 27.
20?
27, 27. Internal, the judgment, my lord, the WPC 133 judgment, which I've just passed over, my lord.
So there's no page 27 here?
No, para 27, page 18.
Page 18?
18, my lord.
Okay, yes.
Agreed. As to the contention of the petitioner union, as regards the alleged discrimination as far as regularization is concerned, particularly the process for regularization of 20 employees, the same 20 employees, the explanation offered by the respondent MECL that the said 20 employees were regularized on the basis of an agreement made between MECL and the landowners, etc., for appointment of their preferred candidates, the same cannot be faulted, since the policy decision of the government in this regard would cover such decision. The said policy is found in the office memorandum number so-and-so dated 30th August 2017, the same memorandum. So in this particular proceeding, they have adopted a very contradictory stand. They've said that they have owned that 2017 memorandum and said that we have appointed, not just appointed, regularized those 20%.
With them being landowner.
Yes, my lord. So now for them to turn around and say in our particular matter that they have no nexus with that memorandum, that cannot stand, my lord.
Yes, Mr. Sahi. Anything else?
Just 3 more minutes more. They've also taken another stand that fault may be mine, but it doesn't make much sense to me, my lord. Their stand is that OM of 2017 does not apply because the appointment of those 20 persons was in respect of some other land in Barnihat. That may be so, but that's neither here nor there. Third ground which they are taking, again a surprising ground, my lord, is that the patta in question in our case, my lord,
yes,
was issued on 22nd March 2017. The patta which I just pointed out, my lord, that is at page 28 of the petition. 22nd March 2017, patta was issued, while the memorandum was issued on 30th August 2017. So they're saying, their stand is that any executive decision, memorandum, etc.
after 38.
We can only have prospective application. It cannot have retrospective application. I have no dispute with that position of law. However, the issue raised in the writ petition is not the issue of the execution or non-execution or the terms of the patta, etc. Patta is a different issue, my lord. The petition is on a different basis. Is the non-appointment of the petitioners. And that non-appointment has continued well beyond 30th August 2017, my lord. Last point which they're taking, a fairly important point, but one which I'll have to meet, is that is of negative equality. Negative equality, this is contained at para 13 of their affidavit. Para 13, in fact, para 13 contains the sum total of their attempt at dissociating from the memorandum. I'll read para 13.
Yes.
At page 8, that the petitioner has incorrectly placed reliance upon the OM dated 11/6/2020 to claim parity in respect of 20 persons mentioned therein, who have been alleged to have been offered regular employment in pursuance of OM dated in 2017, even though the OM only indicates temporary employment. However, despite that, it is submitted that persons mentioned in the OM of 11/6/2020 are in respect of a different land, and the same does not pertain to the facts of the instant case. Secondly, it is submitted that the OM of 11/6/2020 does not confer any right to the petitioner to seek benefit of regular employment under OM dated so-and-so. The same does not amount to adoption of OM dated 38/2018, must be a typo, my lord, by the corporation, and the offer was made in the facts of the case. Lastly, and without prejudice to other contentions, it is submitted that the petitioner cannot claim benefit of negative equality. It is submitted that the OM dated so-and-so is inapplicable to any PDCL, and therefore, even if assuming for the sake of argument that certain persons have been granted employment on basis of an OM which does not pertain to any PDCL, then the same would not confer a right on other persons to claim negative equality and seek regular appointment for donation of land. It is settled law that there cannot be negative equality, and any benefit conferred without legal basis cannot be relied upon as a principle of parity. In so-and-so versus so-and-so, 2013, Honorable Apex Court observed, I'll read, my lord, it is a settled legal proposition that Article 14 of the Constitution is not meant to perpetuate illegality or fraud, even by extending the wrong decisions made in other cases. The said provision does not envisage negative equality, but has only a positive aspect. Thus, if some other similarly situated persons have been granted some relief benefit inadvertently or by mistake, such an order does not confer any legal right on others to get the same relief as well. If a wrong is committed in an earlier case, it cannot be perpetuated. So their stand is simple, my lord. Their stand is that even if in 2020...
How do you take divergent stands in one case and the other case?
Absolutely, my lord. Absolutely. Absolutely, my lord. That is my first response against that. My second response in respect of negative equality is that for them to adopt or to take shelter under the concept of negative equality, first they have to admit or show that the previous action was inadvertent or committed as a mistake, as per their Supreme Court judgment, which they have cited themselves, and I have other judgments also with me.
Yeah.
First, they have to show or admit that it was done inadvertently or by mistake. In this affidavit, they are not saying that. They are loudly silent about that aspect. They are not. There is no positive assertion that it was a mistake committed in 2020.
Then theorem, then yes.
On the other hand, my lord, on the other hand, in that judgment, it's very clear they have completely and wholly owned that memorandum. They don't consider it to be a mistake at all. So negative equality as a defense for them, I would say it's not available, my lord.
Yes,
and just one last line, my lord, one last submission. Another defense taken by them, my lord, is that the patta which we have entered into does not contain any terms of employment, etc., any condition that they have to employ. My lord, patta is a land document. It will contain terms of land usage. It will not contain other incidental terms. So for them, if they're saying that there was no written undertaking on their part, written undertaking is not required. The scheme of 2017 is there. That's all.
Yes, Mr. Say.
Lordship. If I may say so, all the points that I have to argue in response have already been brought before your Lordship in a very detailed and succinct manner. Each and every point has been brought out sequentially. So I need not detain your Lordships very much with each and every one of the points in response. There are primarily three arguments that are there which I need to respond to.
Yes.
First argument is that in terms of the policy of 30th August 2017, there is a legal right that inures to the benefit of clans which offer land for in exchange for employment benefits that would pass on. That's point number one. Point number two is that in fact the 30th August memorandum has been applied in other cases and employment has in fact been granted by the corporation. And finally, the point that has been raised is that the non-inclusion of these aspects in the patta document, etc., may not necessarily be determinative of this issue. And what has to be seen really is if the OM applies, then the writ should be issued directing us to give effect to the office memorandum. Now, Your Lordship, I would just like to indicate three documents at the outset. First would be the offer that was made by, because a lot turns on what was the agreement between the corporation and the clan, which resulted in the transfer of the land. Because essentially this is a negotiation that has transpired in the year 2015. So first document that has to be seen really is the offer. That what was the offer that we made? Invitation to offer rather. On what was the representation held out by the corporation, which caused the clan to pass on the land to the corporation. That Your Lordship will find at page 24.
Yes.
It is of the month February 2015.
Yes. Yes.
As you may be aware, MEPDCL is searching for a plot of land in and around Lab Nongkram area. Accordingly, we have approached the members of your coup and met at site on so-and-so. In the site discussion on part of your authorities, you are willing to part with the land for the purpose of construction of so-and-so substation. As such, we request you to formally hand over the land measuring approximately so-and-so to MEPDCL to construct substation which will be beneficial to the people. Also, as the core land is being distributed to different families, there will be load growth in the future for which smaller substation for DTs also needs to be constructed for about 5 locations for which land measuring so and so or more per location will be required for the benefit of future inhabitants. Also, 11 kilowatt land, 11 kV lines need to be drawn for which necessary right of way may kindly be given. So your lordship will find at this point that what is being asked of the clan is to part with possession of a certain parcel of land for the expansion of the facilities which will be beneficial for the people residing in that area. That's number one. Number two, what representation is being held out, that if the land is in fact parted with and offered to the corporation, then the future needs of the area will also be catered to, since without expansion, it is not likely that the needs of the area will be adequately uh, taken care of in terms of the electricity requirements. So at this point, your lordship will find that in February 2015, when a representation is held out to the clan, at no point is there any reference given for any quid pro quo, other than the fact that in exchange for land, there will be expansion of facilities which will be for the betterment of the people of the clan. That's number one. Number two, your lordship will find at page 24, at my apologies, at page 26, the typed copy, which is the undertaking by the clan. This need not be read out, your lordship, but all I can point out is that the response is also premised on the ground that the benefits which NEPDCL offers in its letter of February 2015 are acceptable, and therefore in terms thereof land is being offered. There is no exchange between the corporation and the clan in respect of offer of employment in the manner that is being sought for in these proceedings. So therefore, the entire edifice of the understanding between the corporation and the clan is not that the quid pro quo is for the purposes of employment, etc., but it is in fact for the betterment of the facilities that are being provided in the area.
Right. Okay. That's one
without
part.
providing.
Sorry to interject.
That's one part.
The thing is that now.
Yes.
What you see, the prayer is plain and simple. It's just that if the same kind of employment has been accorded to other similarly situated people on the basis of some memorandum which it did not deny, then what's the harm in giving them the same, even though it's not written there in even the other also shortcomings which I don't think it appear in affidavit in such cases, but we will not touch upon those. But so you have to answer that. That's all. Yes.
Yes, and
Second
I would
point.
answer that simply by saying.
Yes.
I apologize, Your Lordship.
The
I would
second
answer
point.
that point
Yes.
simply by saying that the office memorandum of 30th August 2017 is a policy decision that came in force by the government, which has been applied in the other case by the corporation.
Okay.
As a measure to ensure that it would incentivize clans from giving lands in certain cases. There was no such policy that existed prior to this. So as on date when the offer was made and accepted, no such policy existed, since the government did not consider it necessary or appropriate at that time for such a policy to be in place. And on mutually agreeable terms, the land was being exchanged, as was done in the case of the petitioners. It is only much later that in 2017 that perhaps as a matter of policy, it was decided that we need to institutionalize this and perhaps provide it in writing so as to incentivize the clans some more to part with the land, and that mutual negotiations by themselves may not be enough. So when in 2015 an offer and acceptance culminated into a decision to part with land, which was acted upon in March of 2017, there existed no such policy. And today, when a writ of mandamus is being sought to be issued before your lordships, there must be existence of a legal right which must necessarily flow from a statute or an executive order or an order which has force of law. Now, when the entire transaction is culminated, at that point in time, there is no such policy. And there are several instances your lordship finds where policies evolve with passage of time, and at a subsequent stage, certain benefits may be given to people which previously was not given to the people, depending on the need and progress of the time. So therefore, this is not a case where there is discrimination. This is a case where on the basis of an offer, a representation held out, an agreement was arrived upon at a time where the policy did not exist. Notwithstanding that, it is not a case where no employment has been granted. That is one aspect of the matter which has not been adequately canvassed before your lordship. It is not a case where employment has not been granted. It is a case where contractual employment, in fact, has been granted from 2020, which continues till date. So therefore, now the petitioner has to demonstrate a higher legal right to seek conversion of that contractual appointment into a regular appointment of the nature that has been granted by way of 30th June 2020 in case of the land at Barnihat. So in essence, what the contention is that this is not a case of discrimination between two parcels of land. This is a case where no policy existed. And this is a case where the petitioner essentially seeks that there must be retrospective application of this benefit, which in my respectful submission may not, because this is a substantive benefit. This is not a procedural benefit. This is a substantive benefit which has to inure to a person. So therefore, it cannot operate retrospectively unless there is specificity in the notification that it shall inure to the benefit of all persons. That is not the case in the present. So therefore, your lordship, on these three counts alone, first, the offer acceptance culminating into an agreement. Two, the non-existence of a policy benefit at the time the land was allotted. And three, the fact that the petitioners have in fact been been granted employment benefits, but seek a higher benefit for which there exists no legal right emerging out of any statute or any rule or regulation which has the force of law. So on these three counts alone, your lordship need not be detained by the issue of it similarly situated persons being granted, because that is not the case in the present. So only these three counts have to be seen, whether on these three counts a writ can still be issued or not. That would be the question that your lordship would have to consider. Those are my submissions to your lordship. I need not get into the aspect of negative equality, etc.
Will pass orders, yes.
Lordship, three responses, my lord. 3 minutes, just for three responses.
No offer accepted.
Yes, ma'am.
OM perspective.
Yes, ma'am. Very quickly, I'll take 3 minutes. First point that was submitted was that the respondent is trying to project that there is a binding contract in a way that was entered into prior to the issuance of the 2017 OM, my lord. A binding contract in terms of the offer or invitation to offer that they extended to us, the acceptance that we extended. A binding contract requires an offer, an acceptance. There is no consideration in this matter, my lord. Have they paid us any lease rent? Nothing. Have they paid us anything that would amount to monthly rents? Nothing. And this is in my pleadings also. Till today, we have not received a single paisa. So therefore, where is the consideration? So for them to say that the arrangements entered into prior to the OM of 2017 amounted to a binding contract that we cannot wriggle out of at this point in time, that may not be entirely correct, for the reason that there cannot be a binding contract that was entered into at that point, for the simple reason that there was no consideration that was present in the arrangement. Number one. Number two, and this is based on the admission, finally the admission has come, that this OM of 2017 has been applied by respondent in other cases.
Yes.
The second point was that prior to the OM of 2017, there was no, because our arrangements were admittedly prior to the August 2017 OM, my lord. Now, the second point is that prior to this, there was no formalized scheme as such. Lordship, that again may not be entirely correct. Lordship, will look at the OM itself. That is at page 41.
41.
41. The OM of 2017. Now, this 2017 OM, it is only an amendatory OM. It amends para 7 of a previous 2014 OM. So the previous unamended para 7 would have contained some sort of appointment scheme. I confess I am not equipped today to place that unamended provision. But to say that there was a complete absence of a formalized structure before August 2017 may not again be entirely correct. There was evidently, there was a structure. Exactly the exact contours of the structure, again, I confess I'm not in a position to assist at this point. But again, the last point that was raised was that the OM of 2017 can only have a prospective application, never a retrospective application. And according to them, what we are attempting is a retrospective application. No, my lord, we are not attempting a retrospective application. The OM itself may be examined to see in what way is the OM to be implemented. The OM contemplates a situation. Reading the OM itself would make it very clear. OM contemplates a situation where first step is grant of land. Once land is granted, then the second step comes that recommendations are made for who are the persons, the clan members you want appointed. Third step is appointment of those recommended clan members. Now, what is the time frame? What is the time period within which all this is to be effected? There is no certainty, there is no clarification, there is no time frame mentioned. So to put it in very simple words, my lord, first step, you grant the land, which we have done. Second step, you recommend the persons, which we have done. Third step is for them to appoint those persons. Finally, into July 2020, they appointed me. They appointed us. But what is the appointment we received? We got contractual appointment. The last point that they are harping on is that, according to them, there is no discrimination that has been practiced on us. Lordship, the discrimination is self-evident. I was appointed in July on a contractual basis. 1 month prior to my appointment, 20 other persons have been appointed on a temporary basis, and apparently from this July judgment, it appears that they have been regularized also. So I would say that discrimination is self-evident. It all goes back to Article 14.
Okay.
The point was raised that I have to project, I have to show on what legal basis do I stand before this honorable court seeking parity. I don't have to spend too much time on that answer. Article 14, my lord. 20 other persons you have appointed 1 month prior to me based on the 2017 OM. 1 month later, you appoint me, but on a completely different, inferior basis. That's all.
Well, pass for
Obliged.
That's all the matters at 2.
Item number 24, the negligence matter is there today, madam. But the officer from the department is here. He is seeking some accommodation today because
that orders have to.
No, that order, I'm not resisting the order, my lord. Here, what happened, my lord? Some mechanism has to be made to how to accommodate, madam.
You can come with a mechanism in 3 days' time, by next week. Accommodate her. We're not
No, 5th
recording
September,
anything.
I spoke to my friend, 5th September is okay.
Yes, some accommodation sought by Dr. By Dr. N. Mozikan at the SGI on behalf of the writ petitioners. On behalf of the respondent. Yes. As is and submitted that some mechanisms being worked out to resolve the issue. Or this is matter on.
Not exactly resolve the issue, my lord.
It's like to resolve the issue. Yes, resolve the issue. It's this matter on 5th September 2024. Yes. Yes.
Hello, pleasure.
Yeah. How much you? Okay, what other matters? Any urgent matters?
item 25 was there regarding an
When you
appointment.
came,
in
my lord,
Igu.
what happened, your lordships? The selection of respondent number 6 has been under challenge.
Seems
Now,
here-
I just got the instruction, my lord, this person has resigned from his post. And he's gone back to his parent department.
What matters? Nehu?
Nehu, my lord, some selection was challenged, my lord, appointment of professor. So, my lord, during pendency, my lord, he has resigned from his post and he has gone back to his parent department. Nothing
Let it
survived.
come up next week, my lord. They can place it.
I'm placing it, my lord.
If I may-
What by item is it?
Item 25.
You're for the petitioner.
I'm for the petitioner.
You're not aware about the resignation.
Lordship. So if I may just kindly have it next week.
Dr. Mangpolan Singson.
Case is that the person who has apparently resigned now was not qualified. That was.
Did you file rejoinder?
Rejoinder is filed, Lordship.
Yes. No, but does he have any other?
Since he has resigned with effect from 18th of August.
No, nothing survived, my lord. Since he has
I
resigned,
need
he's
allowed
not.
to take instruction on this. Kindly
What
have
is
it.
what instruction? I've given him a call.
Let him take instruction. In all fairness, he has to take material instructions also. Yes. It's informed item number 25 that
25.
petitioner Patricians resigned from his post.
No, the respondent, Lordship.
Respondent number 6.
His appointment is
still been
under
for
challenge.
who? Respondent number 6 has resigned.
Yes, this Dr.
Yes.
Shukla.
And it's been informed that number 6 has since resigned from his post, against whom a challenge appointment has been made.
Lordship.
Challenge selection has been made. Stop. However, Mr. SD, please allowed to obtain instructions. This doctor, this on Monday. Yes. Next coming Monday.
Obliged, Lordship.
Obliged.
26.
26. Rejo.
My lord, this is a VC matter, my lord.
It's not an easy matter.
Yes, my lord.
It's not an easy matter.
My lord,
VEC matter,
my
Your
lord.
Lordship.
Oh, VC matter.
VC matter, my lord. Yes, my lord.
Yes.
Village Employment Council, my lord. My lord, during the existence of the VEC, my lord, the new VEC had constituted by the respondent, my lord. Yes, my lord. That is the only case, my lord. We are seeking for a direction to conduct free and fair election, my lord. That is the only grievance, my lord. And a new development, my lord. Today, my lord, I just received my lord, the present president of the VEC. She has tendered her resignation from the post, my lord. May I submit, my lord, this one before.
Are you aware of that?
No, Your Lordship.
Today, my lord. Today, my lord. We receive instruction, my lord.
Mr. S.K. Hassan submits that the matter concerns the prayer for a free and fair election.
Yes, my lord.
To a new VEC staff. He, however, also informs that the current secretary of president,
my lord,
has
responded.
resigned. Next, MSZ normally to take instructions. Let's up to 1 week.
Obliged, Your Lordship.
Copy of the what material handed over to the council. That's it.
Highly obliged.
I thought a negative matter will take time. That's why I was going to sit at
Yes, ma'am.
Yes.
Highly obliged.